Hello, everybody. Thank you very much to Patrice and Jean and everybody else organizing this to have a few minutes to talk a little bit about our Sunshine in Government Award. The Sunshine in Government Initiative, which I'm coordinator of, was founded in 2005 to promote common sense policies and practices that promote transparency in government and to push back a bit against growing government secrecy at the time. And one of the things we noticed, as all of us know, is that there are too few incentives within government to promote transparency. And so one thing we did was to address this problem, was to create the Sunshine in Government Award and design what I think, it wasn't my doing, it's a very handsome award, to really, identify those folks in government who really are doing a good job. And this year, we have 3 individuals, and I'm looking around at the table or at the doors to see if they're here. We have 3 individuals we are honoring across 2 branches of government for 2 efforts that we think have done an enormous amount of good to promote transparency. Our first recipient this year is Senator Ron Wyden. Senator Wyden last year responded to legislation that was passed by the Senate Intelligence Committee that would have done extreme damage to the ability of news reporters to cover national security and foreign affairs. I'm not going to go into the details, but we were extremely concerned about the steps it would have taken to address concerns that the committee had with unauthorized disclosures. And so to address this, Senator Wyden was the only senator in the committee to vote against the provisions. And then he stood up on the floor of the Senate and put a public hold on the Senate, on the Intelligence Authorization Act for 2013 because it contained these damaging provisions. And because he did that, and through the efforts of others, including Senate Judiciary Committee Chairman Patrick Leahy and others, at the last hour in the last days of the last Congress, the Senate had to drop those anti-leak provisions from the Intelligence Authorization Bill and move that forward, and thereby avoiding this damage. And for his efforts, we will be finding a time in his schedule when we can actually present the award to him in person. He's got his own copy of the award, and so we appreciate his efforts. Our second and third recipients are Tim Crawford and Larry Gottesman from the Environmental Protection Agency. Unfortunately, they may not be here today. Tim and Larry, working with their partners at OGIS and the Department of Commerce and others, took a system that they had already developed within government to deal with one problem and, in essence, recycled it and created what is known now as the FOIA online system. It allows, they say, it allows taxpayers to save taxpayer dollars. It improves FOIA delivery. And we think it holds tremendous promise. You heard a little bit about it in the discussion this morning. As I mentioned, unfortunately, they may not be here today. And we are reminded about how important it is to provide this award to people who cannot or who are promoting transparency in government and face tremendous obstacles to overcome that. And I think it may be easy to say the message here is, well, isn't it ironic that an administration that devotes its commitment to transparency has this inability to present people for this award. But really, I think the story is what these folks have achieved in even bringing this promising system to the point that it has. And they've overcome obstacles, and it deserves our support. It deserves the support of people outside of government, and it deserves the support of their senior leadership within government and of the White House. And we encourage that system to be developed. And we will find a time in our schedule to deliver that in person. At this point, I want to recognize the people who are involved in that project, including the OGIS director, Miriam Nisbet, who's done a tremendous job in advancing that and ensuring that it gets the public exposure it needs to grow and develop and to see if it actually can achieve the promise. So thank you very much. I know I'm keeping you guys from lunch. So appreciate it.
Hello again. I'm Ken Paulson with the First Amendment Center, and we have some new faces in the room. I was delighted to see the group here from Mizzou, my alma mater. I intuitively wore the school colors here today, so it's a mere coincidence I also work at Vanderbilt University. So our keynote discussion today centers around a new book, Nuanced Absolutism, Floyd, Abrams, and the First Amendment, which is an insightful exploration of the many contributions of First Amendment attorney Floyd Abrams. And this is a man whose work has both shaped and fortified First Amendment law literally over decades. Today we have the special opportunity to have the subject of the book, the author of the book, and a leading journalist with an extensive background in the First Amendment here to ask questions and generate conversation. Everyone in this room knows the extraordinary work of Floyd Abrams, and he has appeared frequently in the Supreme Court arguing cases on the First Amendment, copyright law, broadcast regulation. And he has represented the biggest names in American journalism, including the New York Times and the Pentagon Papers case, Time Magazine, Business Week, CNN, ABC, CBS, ABC. You can almost make a list of, he's represented virtually everybody. And for 15 years, Floyd was the William J. Brennan Junior Visiting Professor at First Amendment Law at Columbia Graduate School of Journalism. And although we know Floyd, of course, for his many efforts to defend the First Amendment, it's also important to acknowledge the impact of the way he thinks about the First Amendment. And that, of course, is at the heart of this intriguing new book. The author of the book, Ron Collins, he is the Harold S. Scheffelman Scholar at the School of Law at the University of Washington. I'm proud to say he was also a colleague of ours at the First Amendment Center, a scholar with us for many years, who often had that great skill to take complex First Amendment issues and translate in a way that the American public would understand and appreciate. A true scholar, and his contributions were invaluable. He also is the author of The Fundamental Homes, a free speech chronicle and reader, and the upcoming Dissent. I tried to pick out the books that I think you currently get royalties for, Ron. I have to tell you, although I admire all of Ron's books, my personal favorite continues to be The Trials of Lenny Bruce. And if you don't have that, it belongs in each and every one of your libraries. Finally, our moderator for today's discussion is Tony Morrow, who is a Supreme Court correspondent for the National Law Journal, American Lawyer Media, and Law.com. And he also, again, writes for the First Amendment Center's website, and he does a phenomenal job. He has covered the Supreme Court for 31 years and is the author of Illustrated Great Decisions of the Supreme Court. And congratulations in particular for being named the chair of the Reporters Committee for Freedom of the Press. Congratulations, Tony. The stage is yours.
Thank you, Ken. And it's a great honor for me to be the moderator of this panel for two First Amendment experts who really need no introduction, and they probably don't need a moderator either. But I'm very glad to do that duty. I've admired and quoted Floyd Abrams for probably 3 decades at least, and I've known Ron and worked with him and admired him as well for almost as long. As Ken mentioned, it is sort of unusual to have a panel composed of both the author and the subject of the book, of the same book, and on this panel. And so, as I ask questions, I may ask them of one, but it can be presumed to be a question for both of you, if you want to chime in. So let's begin. Our time is short, and toward the end of the hour, we very much want you and hope you and the audience will join the conversation. Why don't we start first by asking both of you to talk briefly about how this book came about and its title as well, Nuanced Absolutism, which sounds a little bit like an oxymoron, like Diet Twinkies or something like that. But Ron, do you want to start?
Well, thank you for exercising your First Amendment rights there, Tony. First of all, just at the outset, Ken, Jean, Ashley, and all of my other colleagues here at the Newseum and at the First Amendment Center, it's good to be home. And so thank you again for making this event possible. So how did it begin? Well, let me just tell you, caveat emptor if you communicate by email with Floyd Abrams. It started, I had just finished a book on Justice Holmes and sent him a copy, and he sent me a very kind email. And kind of as an aside said, I see that you noted my name in a particular case that he'd argued. Did you know that? Had you looked at the briefs in the case? Had you looked at the oral arguments? And my first response was, I didn't respond to him, but I thought to myself, I mean, my God, I mentioned the lawyer. How many times when you read in a book, law book, about a Supreme Court case, do they ever mention the lawyers? I mean, right? So I'm thinking, this guy's, this is a bit much, right? It's not enough that I mentioned his name and I spelled the name right? So anyway, I went.
You never told me this before.
You might not be here today if I had. So I went and read the briefs and the oral arguments, and I was amazed. I really was amazed. And I must tell you that as a law professor, you have to see the world as we see it. We teach students cases, all right? We never mention the lawyers. We never mention their work. We never look at their arguments. We assign to the students these cases as if these great ideas just came from the minds of the nine, as if there was nobody involved at all until the case got to the Supreme Court. So I started reading, and of course we read law review articles because those are the things we publish, so we read each other's work. But one thing we don't read is the things that lawyers do. So I started reading these, and I would correspond with him. I'd respond, that's incredible, that's amazing, And he said, well, I have another brief, and he'd send me another one. And it was even more interesting. He said, well, if you like that, by the way, that point that you just made, there's a speech I gave at Yale in 1988. You might like to look at that. And believe it or not, there was like 100 emails. You can't believe how much unpublished work this man has. But it will be coming out in a book this May called Friend of the Court. Well, anyway, I started writing what I thought was going to be a little blog piece. And then he sent me more. And then it became a little law review article. And then he sent me more. And it became a long law review article. And he kept sending it. And one other thing. Sometimes I would ask, I know it's hard to restrain yourself, right? I would ask him a question, and he would write back and say, well, take a look at page 3, paragraph 2. And lo and behold, the very question I asked was answered there. And the more I began to read Floyd's work, one word kept coming up in my mind: nuance. He's a careful thinker. He's a careful writer. He's a careful litigator. More about nuance than absolutism in a moment. But from my side, that's how it all began. Right to reply?
You'll understand this is a somewhat awkward position. Not at all unpleasant. I have no idea what you're doing.
Make sure your phones are off. One of them is ringing and coming through the speakers. Sorry, didn't mean to interrupt.
I don't think so.
Did you call me?
Somebody's cell phone.
A cell phone. Why don't we go? No.
Is this a Fourth Amendment search? A Terry pat down.
Mine's off.
Right, okay.
Well, first, I assure you, I didn't send him anything he didn't ask for. Right? But it is true that he would raise subjects, not sometimes questions, but more topics. And in situations in which I've given a speech about them, I thought, well, I'll send him the speech. Whoever asks for my speeches. It seemed to grow from there. And I mean, we did have a lot of exchanges, including exchanges about very recent thing. I mean, I'd write an op-ed piece for the Wall Street Journal, and he would write me a note saying, in effect, you never quite answered such and such, a particular issue I had decided not to answer. So, he'd write, well, what do you think of that? And I would have to think about it. And I answered. In any event, here's the book. I'd say one other thing by way of introduction. No lawyer who does First Amendment work can, in a court, accept the label of being an absolutist. Absolutism sounds, as one of the speeches I gave observed, dumb. To say you're an absolutist about something really has to mean that there are no circumstances, no hypothetical, nothing which could lead you to change your mind, that this rule's got to be just what it is. I mean, if you're an absolutist on capital punishment, against it, it means Hitler, too. It means a child killer, too. Pick your worst example of someone who you might think does deserve capital punishment. If you're an absolutist about capital punishment, you have to say there too. And so in the First Amendment area. And in the First Amendment area, you have to be prepared to say, even if publication will do the worst harm, immediately do the worst harm. National security in peril, the country at risk. Even then, if you're an absolutist, even then you have to say no exceptions. The First Amendment says no law. No law means no law. And even Justice Black, the most absolutist of all our Supreme Court jurists on the First Amendment, even Justice Black had to deal with that by saying, well, spying isn't what's covered by the First Amendment. And perjury isn't it's speech, but that's not the sort of speech the First Amendment is about. I mean, there will always be some area as to which everyone will agree that even though it involves words, it's not protected. And so it seemed to me for some time that one can be an advocate for extremely broad reading of the First Amendment without at least self-adopting the word absolutist, which is one of the reasons that when Ron chose, and believe me, I had nothing to do with it, chose to characterize my view as sort of a nuanced absolutism, I was quite comfortable with that. You can say, if you really want to parse it,
He's being nuanced.
It means you're not really an absolutist. but
you know what? One of the things where this came up is there's, and he had brought it to my attention. Floyd had brought it to my attention. The oral arguments in the Landmark Communications case, and there he's really having a good time. At least it looks like that from the transcript. With the justices. And Justice Rehnquist is trying to take him down the clear and present danger road, and he doesn't want any part of that. Of course, this is the law, but he's holding his own. And then Justice Stevens, and I can almost see Stevens scratching his head, said something to the effect, well, Mr. Abrams, I'm not really quite sure which test you're advancing here. Well, he wasn't advancing any of their tests, really. He was advancing his own test. And the idea of nuance is where it came in. He said, I'm paraphrasing here, if you have a certain set of facts, so facts relating to a public figure, and you have a certain entity, the press, and they're reporting about a public figure, okay, and that information was otherwise lawfully obtained, you cannot criminally prosecute that person. Now, there was just a number of qualifiers, you see, and then once you plug in all the qualifiers, then bang, that's where the absolutism in that sphere. And it's really, at least as a law professor, I think it's the way law should be taught. That is, from the lawyer's perspective. But I cannot begin to tell you what a foreign concept this is in law schools.
Well, I want to develop that a little bit because, as you said, one of the features of your book is that, and the premise is that lawyers don't just argue cases, they also, or at least this lawyer has argued cases and shaped the law. And I want to, how has he done that? And also, Floyd, are you comfortable with that notion, since the first duty of a lawyer is to win the case and not necessarily argue a cause?
Well, Floyd's case is a little different than your typical lawyer. I mean, he's been tilling the same fields for, well, a long time.
A few years.
A few years. Right. A few years. Youth isn't what it used to be. And so when you have somebody who has worked a particular field for a long period of time, you begin to see the lawyer's craft, particularly as you go from case to case, from brief to brief. And not only that, but also in public writings and speeches that he gave, and articles that he wrote, in a book that he wrote. And from that emerges, if you will, a view of the First Amendment. We typically, when we talk about the First Amendment, scholars have views about the First Amendment, book writers have views about the First Amendment, law professors clearly have views about the First Amendment, and judges, right? But when's the last time you ever heard of a book about a lawyer and with his view or her view about the First Amendment? And so that's how this came to pass as I looked over 4 decades of work in this area and began to see that indeed Mr. Abrams' notion, or as my notion, it's my words, nuanced absolutism, how it played out in a variety of contexts, in a variety of cases, from the Pentagon Papers case to Citizens United to WikiLeaks and what have you.
Yeah, I want to distinguish two types of situations, because I think Tony's question is really, really important about what lawyers do. It's perfectly true that the lawyer's first obligation is to the lawyer's client. I argued 2 cases in the Supreme Court representing people on death row. I was deeply offended that the group, the anti-capital punishment group that asked me to argue them, started proposing things for me to say which I thought would not be in the interest of these guys that were going to be executed, because they exist for the cause of ending or limiting capital punishment. And they thought this might be an opportunity, to get the court to say this or to avoid the court saying that. And my view was I represent an individual, let alone someone at risk of execution. And I don't want to say anything which could limit to any degree the chances of winning the case. Now that's somewhat different from what I viewed as the sort of cause cases that I've often, but not always, often done for the press, where the organization itself has an interest in establishing a more expansive view of the First Amendment, and are prepared to take some risks in the litigation process of having me argue for a somewhat broader view of the First Amendment, even if that could irritate 1 or 2 of the justices, and therefore possibly have some impact against us. I mean, nobody, I wouldn't do it if I really thought would have an impact against us, but it's a higher level of acceptance of risk in that situation for the good of getting the court to say something more rather than less expansive about the First Amendment, at least as I view it and as I hoped my clients viewed it. But that certainly is not the way I felt in my capital punishment cases. And whatever the case is, I mean, the lawyer has got to remember, I didn't make up these cases. This isn't my case. This isn't just a game we play to please my ego or my sense of wanting to establish this or that in the law. I mean, there are real people are going to be affected, and real people are at risk, and real people have to be represented with the zealousness that lawyers are supposed to exercise.
I want to ask about the national security area. Ron's book goes into the fact that after 9/11, your sort of absolutist views on the First Amendment were at least tested but not broken. And a dozen years later, we're still grappling with clashes between perceived national security interests and the First Amendment. What's your current view of that balance, and in particular, just to give a prime example, what are your thoughts about Julian Assange and whom you have criticized?
Right. Well, first, I think it's really important to make a distinction between what I think the law ought to be and how I think people ought to behave. People find it sometimes much easier to represent Nazis and people who are really outrageous, because everyone will understand that you don't really share their views anyway. You're doing it for the cause of free speech. Easier to represent Nazis than to represent people that do other offensive things which may really bother us. And as we have that in mind, I think it's important to bear in mind that, first of all, I have First Amendment rights too. I think WikiLeaks has often been reckless and sometimes dangerous. And I've said so because I've been irritated at the process of viewing them as heroes, or Bradley Manning, who is the leaker of a lot of this stuff, as some sort of hero. I don't think they are. And I used a phrase in an op-ed piece I had in yesterday's New York Times of their devil-may-care, now I can't remember the next word, the devil-may-care, now, well, I'll try it. I loved it so much when I wrote it. I really did. I quoted myself saying it. Obliviousness. Their devil-may-care obliviousness to genuine needs of national security, which is my view and my basic criticism of WikiLeaks. That's a personal view of mine. That's why I don't especially honor them, even though some of the work they've done actually I think has been useful. But taken as a whole, I've been more concerned than pleased with what they've done. But I think they're entitled to First Amendment protection. And I argued yesterday in the New York Times that even Bradley Manning, a private who apparently released millions, at least hundreds of thousands of pages of classified material, which in my view he ought not to have done, most of which, by the way, WikiLeaks never read before even sending out to the world. But I thought the idea of the government now charging Manning with what is basically a capital offense, an offense where he could be executed, the government isn't asking for it, for aiding or helping a foreign country. The theory being that when he leaked the information, he knew it would be made public and therefore knew Al-Qaeda could get it and therefore knew that he was, in effect, aiding the enemy. Well, my view is that would be extremely dangerous to the ability of the press in general to gather information and the public in general to be informed. So my view is that the First Amendment protects a lot of activities which I, as well as lots of other people, may not agree with or honor. And that's just one example. There is a balance which I think has to be struck on a behavioral level. On the First Amendment level, we lean very much in favor of more speech and more information rather than less. And I think that's the right way to lean. What do you think?
I'd like to quote Floyd Abrams. Do you mind?
Awkward, I said.
Actually, since they're your words, I probably should have you read them, right? When Floyd talks about balancing, this is not the kind of typical sort of balancing that we might think of. Let me quote from something Floyd wrote in 1988. Each society chooses the risks it is prepared to take. As a general matter, this country, more than any other in the history of the world, has chosen the risks of allowing free speech rather than the risks of suppressing it. And so you see there that there is at least a presumption that could be overcome of protecting speech. And I think it's important to keep in mind, and you see it in Floyd's writings, when you protect free speech, at some point, if that protection is to be meaningful, you have to take a risk. The question is, how great does the risk have to be? The other thing I'd just like to add to what Floyd said is that he had pointed this out to me, that the New York Times has received a lot of information from Julian Assange, most of which, the vast majority of which, it is not deemed appropriate, for lack of a better word, to publish. So when I was writing the book, Floyd was getting a lot of flack because he was saying that he thought this was irresponsible journalism that Julian Assange, if I can call it journalism, was engaged in, or at least parts of it. And so we kind of kept going back and forth in emails about, well, this view about journalism and journalistic responsibility on the one hand and First Amendment protection on the other. And, you know, this is somebody who takes journalistic responsibility very seriously. And, you know, quite often you don't see that. You just see that, you know, there's, you know, the press is protected, end of discussion, as if the press didn't have any of its own responsibilities. So that is something that kind of found its way into the equation.
But do you think that Julian Assange or Bradley Manning are either journalists or equivalent to or undistinguishable from journalists?
I don't think they're journalists. I think the best example of that is when Manning apparently gave to WikiLeaks 79,000 or so military reports from American soldiers in Afghanistan. At that time, Assange was under a great deal of criticism of the sort that I still directed him for alleged recklessness. And they didn't publish, at least at the start, about 12,000, I think. But they did release, call it 60,000 of these reports. And a journalist asked Assange at a press conference, how many of these have you read? You and your people read before you released them? And the answer was about 2,000. And Assange said, we have no reason to think the other ones would compromise national security. And my reaction is, whatever else that is, we're not talking about journalism anymore. Journalists don't release 70,000 documents without reading them. But that's not an answer to the question of whether it's First Amendment protected. Journalists aren't the only one in our society that get First Amendment protection. I mean, Dan Ellsberg wasn't a journalist, he was a source. Manning is a source, and the role played, in my view, by WikiLeaks is much more that of a source than as a journalistic organization, particularly when they, at least in the past, would make documents available to journalistic organizations, genuine journalistic organizations, and let them decide by their own internal pruning processes what to publish and what not. So I'm not sure in the end it's going to make a legal difference, or that it should. whether what Assange does is journalism or not. We protect pamphleteers, remember, as well as big newspapers. We protect, someone that has a single billboard or a single photo as much as the most important publisher. And it's very important that we continue to do that, and we do that without regard to what label we put on the person, as journalist, non-journalist, pamphleteer, non-pamphleteer. So, I mean, I think they are entitled to a great deal of First Amendment protection. Now, look, Manning, again, Bus Horse, has already pled guilty to releasing classified information. I think it's perfectly constitutional for the government to make it a crime to release certain types of information. And that's a different question of whether it's constitutional to make it a crime for the Washington Post to publish that information if it receives it. People who are in the government, who have access to certain documents and information, have a different level of responsibility and obligation with respect to what they do. So it's complicated sometimes, as life is, but
Nuanced, right?
it's nuanced, yeah.
I like that idea. Oh, go ahead.
Yeah, we should move on a bit to, you took even more heat, I think, Floyd, from over the positions you've taken in campaign finance cases, in particular Citizens United. You've been portrayed as a friend of big corporations that want First Amendment protection for the money they pour into elections. Why do you think it was so hard for some of those who embraced the First Amendment to understand that the positions you took flow naturally from the First Amendment?
Well, first let me say I've devoted most of my life to representing big corporations like the New York Times and other entities that put out news, what they view as news, or views, or the like. So I came easily to the view, which has never really been at issue, even in the Supreme Court, even with the dissenters in Citizens United, that corporations receive First Amendment protection. The dissenters in Citizens United thought that protection could be overcome because the interest in fair elections or getting rid of so much money in elections was so important that in that area they could overcome it. But no one in the court, no one, thought that because it was a corporation at issue, that it didn't have any First Amendment rights. Yet in part because of what I think is sloppy reporting, and in part because of what I think is ideologically based reporting, a good part of the country, which by all accounts thoroughly disapproves of the Citizens United ruling, think that what's wrong with it is that it's allowing corporations to speak, when that's been the law way back. And as I say, was not a subject of dispute on the court. I'll say just one other general thing about it. I started, and this is consistent with, I guess, what Ron was saying earlier about, lawyers view things differently, practicing lawyers differently than judges do and some others do. I start with the case itself before we get to the broader implications of it. Here's a conservative group, which is a corporation, which makes a movie denouncing Hillary Clinton when she was the leading likely Democratic nominee in 2008. Then Senator Obama had not yet gone past her in terms of the Democratic Party. So this conservative group, which receives some, but actually not even a whole lot, of corporate money, and is itself a corporation, does a sort of quasi-documentary, one that I think was a hit job, on Senator Clinton. I mean, it's just, she couldn't do anything right. The whole theme was she was unqualified to be president and would be dangerous as president. Well, my reaction was, how can that not be protected? Saying about someone running for president that she's not qualified for the reason they believed, and because it's a corporation or because the money that is spent making this movie, which under the statute at issue governed material on television or cable or the like, or satellite, within 60 days of an election, that they couldn't run anything naming the person, the candidate. So here they wanted to run on the equivalent, I'll call it television, pay-per-view really, a documentary criticizing, and very harshly criticizing, the likely candidate for president of the Democratic Party, and that was a crime? Well, by my lights, before you get to any of the more sophisticated First Amendment issues, that was easy. And I appreciate that has not persuaded the American public or the press, which has been overwhelming in its denunciation of the opinion. But starting from there, my view is that there are a few reasons why the opinion is so unpopular. One is that we do have a problem. It's a real problem about the money in politics and the like. It's not a feigned issue. But another, I must say, is that I think one of the problems journalists have is that they really think the First Amendment belongs to them. And the idea that corporations, as if they don't work for them, have First Amendment rights too is very disagreeable.
Tony, can I put a tail on that?
Sure.
I'd like to just use that opportunity to say a few things about the Roberts Court. I just finished a long article in the Albany Law Review about coming out on the Roberts Court. It depends on what lens you look at the court through, your view of their views on the First Amendment. So in terms of fortifying the First Amendment, they've done so in cases involving crush videos, violent video games, false statements regarding military medals, and of course the Citizens United context. My colleague Bob Cohn-Revere played a very active role in a number of those cases. Some see those cases as trivial. I think in many respects they're very important. I think that in many respects they fortify the First Amendment in very important ways. On the other hand, so if you look at the Roberts Court from that vantage point, your views are raw. They're correct. It's a good court. What about student speech? Disaster. What about employee speech? Disaster. What about the Humanitarian Law Project, so-called aid to terrorist groups? A disaster. Now, those are important cases. Those are very important political speech cases. So I think you have kind of a mixed view. You can say, on the one hand, well, they're there defending corporate interests, but when it comes to the real nitty-gritty stuff, employee speech, student speech, political speech, right? The Humanitarian Law Project obviously involves some very important political speech. They fail. I don't think it's that simple. I think that there are just a very number of some of these cases that may not seem important, have very important doctrinal components to them, and I think they do in many respects help to fortify the First Amendment. But then again, as I said, there's a downside. So, it's kind of a mixed bag. I'm kind of curious about your take on that.
I guess I'm a little more affirmative than you are on about the court, and even some cases I don't agree with, where they haven't come out on the First Amendment side. I think we're pretty close cases. The humanitarian case,
5-4.
Not just 5-4, but I'm just saying that I view it as a close case. where the government was really saying, if you give money or provide free services to an organization deemed a terrorist group by the government, that in certain circumstances, without going into that can be illegal. And the government position is set forth by then Solicitor General Kagan was that if you, let's say a terrorist group, as defined, has a hospital. If you give money to the hospital, on the one hand, you're giving money to a hospital. On the other hand, you're helping the enemy because money is fungible. And her argument was that the money was fungible, and therefore that no matter how innocent the particular activity was for which the money was being spent, that it was still not protected, and it shouldn't be protected. Well, like Ron and like the four dissenters, even though I agree on the fungibility of money, I don't agree with that ruling, but I think that's a lot closer case than most of my First Amendment-oriented friends think it is. So I'm not as critical of the court for coming out in the way that I wouldn't on that.
Just one editorial comment, since you mentioned Elena Kagan. Bob, and help me if my memory fails me, but isn't she the same one that called for a new exception to the First Amendment in one of her briefs? Or they? So anyway, rhetorical question there.
But overall,
She'll be all right.
Okay.
but overall, Floyd, you agree that the Roberts Court is pretty much a strong.
I do think it's a strong First Amendment court, and I think that some of these opinions in recent years would never have gotten a conservative vote all the way back when I was in law school, but for many years after that. I mean, these are horror story cases. These are cases where you have to hold your breath before you say we ought to allow that speech. People demonstrating 1,000 feet from a church where American soldiers died, and with signs saying basically with the word fag in the signs, and saying this is God's, he deserved to die, the soldier, because it's God's punishment of the U.S. for being too pro-gay. That was the theme. And, I mean, you really, I was grateful no one asked me to write an amicus brief. I'm glad they won the case. Doesn't have to be me, and other cases, animals being tortured to make movies, animals, little animals with women in high heels stepping on them. Horrible stuff. And the torture of animals is illegal in 50 states and under federal law. And the question was, well, could you punish the filmmaker who films it and sells it? And the court, for various reasons, but the court, for First Amendment reasons, said no, that's different than engaging in the act, the criminal act itself. And these are only in America opinions. I mean, no country would imagine protecting that didn't have a really live, vibrant dedication to the notion of a First Amendment, which allows even stuff like that to be protected. And so I give the court a lot of credit for opinions like that.
I've developed a standard that I call firstiness, the degree to which the court used, how robust the First Amendment language the court uses in protecting offensive speech. And on the firstiness scale, I think the Roberts Court has done very well.
One last plug. We're talking about the Roberts Court and the judges. I'd like to give a plug to the lawyers in those cases that we've just been talking about, Patricia Millett, Paul Smith, Bob Cohen-Revere. if you want to see where a lot of those ideas came, look at those briefs, which brings me back to the importance of looking at the work of what lawyers like Floyd Abrams do.
Well, before we turn it over and solicit questions from you all, I just want to get your thoughts, Floyd, on this FOI Day, the current state, in your view, of our First Amendment freedoms, and particularly press freedoms, and the Freedom of Information Act, even, which at one point, you were not so keen on. So.
Yeah. In the heady days of the 1970s and early 1980s, there were a lot of journalists who thought, and people like me who thought, why should the press, the autonomous press, go to the government and beg, entreaty the government, please let us have information. And I was one who thought, well, it's unseemly. They do what they do, and if our team gets it, we'll print it. Right? You leave us alone. We don't have any right to it, but we can put pressure on you to give it to us. And I came to a more measured view when the court got more and more conservative before it started to become libertarian conservative on First Amendment areas, and decided that there was no reason for me to be consistent about my views about any of these things. Why didn't we just all support the things that would lead to more information somehow? And I think the Freedom of Information Act is another American treasure. I mean, it really is. It doesn't always work, and it leads to sometimes unbelievable morasses and time passing and money having to be spent. But again, it's an American original, and it's a very good idea, and I think we ought to have more of it. On the pure First Amendment level, we mentioned 9/11 earlier. If you just try to look at this from 30,000 feet, what would the law have been any place else in the world after an attack? I mean, a murderous attack that kills 2,500 people and is an act of war and terror. What would the law have been in most other places about being really able in the press to continue to say anything? I mean, really, just anything, however critical, however defamatory, however unfair about the government at a time when one would like as much unity as possible. Now, in truth, there was a lot of unity in those early days, but there were also people saying some, very offensive, outrageous things, and in the private sector, some of them paid a price for doing it. But no one ever went to court. No one was ever arrested. I mean, we just live with that. It's just part of life here. I mean, American culture, I think, as well as law, is very good on that sort of level. I mean, it's always seemed to me really interesting that in Great Britain, the Queen brings lawsuits. The Prime Minister sues for libel routinely. Here, I mean, President Obama brought a libel suit. I mean, it is unthinkable, literally unthinkable, whatever they say. And that's true of all of our presidents. Just thinking of it, and our senators and our governor, it's just off the table. Now, you can argue about how much freedom one country has versus another at the end of the day, but I really think, especially on a day like today, we really have a lot to celebrate.
Ron, any thoughts? All right, any questions or comments?
I might I've restrained myself all day from asking questions, but I'd like to, and we'll go right there. And this presages a bit the program that's going to follow this one, but we've seen varying levels of success in the government in closing off whistleblowing, closing off people who are sources. Manning is a case where there's a body of law on the military side about disclosing secrets, and so to some degree he's over here. There seems to be a new strategy, and maybe it's not new, and this is the heart of my question, to deny a range and impose a range of penalties, the loss of a pension, this sort of exclusion from all future employment of the government, in addition to prosecuting. Rather than prosecuting journalists, it's going back to chasing down the sources, and it's more than that often said but fairly infrequently followed up, we're going to close down the leaks. Do you see that from your point of view, Floyd? Do you see this increasing attempt to attack the source rather than the journalist in terms of these things?
Absolutely. Look, no administration has been as diligent, one way to say it, or as willing to go after sources full bore as the Obama administration. Now, that may come from within the CIA and other, government agencies, and it may be that there is, less of a willingness of a Democratic administration to resist the entities with which it is least comfortable, the military and the like. But whatever the reasons for it, there's no doubt, I think, that they've gone after more sources. Now, this is a very complex issue on a purely legal level, which wasn't what you were asking, because sources don't have anything like the rights to leak as the recipients, the journalists, do to publish, because they have certain obligations, certain legally imposed obligations. Most administrations have been sotto voce, have been sort of quiet in this area, and have made a policy decision that they would not be the administration with all the other problems they have with the press, that was going to be labeled anti-First Amendment or anti-press or whatever. For whatever reasons, that this administration has done just the things that your question identified and continues to do so.
I wanted to ask you about a case or about laws that are the flip side of the other animal ones that you talked about. In the Midwest, a number of states have adopted what are called ag-gag laws.
Yes.
And I teach in Indiana. We're on the verge this week or next week of passing one of those as well. And one of my students, a student journalist, is going to be testifying against the bill. I wanted to ask two questions. One, how you think those laws will fare on court review. And the second, if you have any advice to my student, whom I think may be listening to this, as to how to frame her arguments before the Senate committee.
Well, I think the two most important things that the students can say when they can say them is, one, what they're saying is true, or if they're not facts but opinions, that opinions are always protected. Justice Powell said a lot of years ago, there's no such thing as a false opinion. We provide enormous protection. Ron mentioned this case that I'd been active in around 1980 or so, where we were arguing that truthful speech about matters of public interest should always be protected. It is in libel cases. So I certainly think they ought to emphasize, again, where they're talking facts, that you can't punish the assertion of truthful material, and when it's opinions, that opinions are historically protected under the First Amendment. The other thing I think is most important for them to get out is why it is important to talk about issues like this. I mean, these are not narrow issues. They deal with the safety of the food we eat. They deal with the quality of the agricultural products that the nation has, and to allow, in essence, now I'll use the word in a derogatory way, corporate silencing of criticism on important issues like this is very dangerous.
Just a quick couple of comments. This brings back to mind the veggie libel cases, much of these issues, the Oprah case where people quote-unquote libeled cattle. And the Center for Science and the Public Interest has a wonderful resource site on a lot of that legislation. There's a couple of new articles on it. Also, the importance of anti-SLAPP statutes, working with members of your press and your state association, because in a sense that's the best way to strike down, to really get some immediate action in the area. So those are my suggestions.
And the fact that in Indiana it would criminalize only taking photographs, and truth would be explicitly excluded as a defense.
Yeah. Well, they know what they don't want.
So I assume from the answer to that is that you think that these laws will not fare well when they're challenged.
I don't think it will, but I mean, I think they ought to. I mean, a facial challenge to that statute seems to me promising.
Thank you.
And be sure to raise the free speech claim under the Indiana Constitution as well.
Thank you.
I'm curious also, there's a lawsuit going on right now, the pink slime case. I think it's in North Dakota, brought by the company that produces the chopped, formed, and extruded meat product, as I believe the term is they would prefer, and they're suing ABC, I believe it's ABC News, for repeated use of the term pink slime, which was actually coined by a government researcher. But anyway, there may be something in that that's instructive in terms of this whole issue of derogatory commentary toward agriculture and meat products and the rest. So, next question.
Hi, I don't know if you can hear me. Elaine Middleman. Yeah, hi. I'm an attorney, but I'm a very big believer in the First Amendment. Or I shouldn't say but, maybe and. But your comment, Mr. Abrams, about you didn't need the Freedom of Information Act because you had the New York Times reporters out there hustling in the 70s. Yeah. It made me think that now, like in my dealings with the press, the first thing you hear is they don't have enough resources. The people are getting laid off. And the stories that a lot of times they do write are so simple and lacking in research or, about Justin Bieber or something. And I really want, and then you have Twitter, of course. But I just wonder if the First Amendment itself is kind of under a dark cloud when the newspaper business seems to be struggling for its own survival.
Yes. I mean, these aren't attacks on the First Amendment, but where the press itself is wobbly because of economic pressures, wobbly in terms of survival. Because of economic pressures, there's no doubt that their ability and sometimes their willingness to go after certain types of stories can only suffer. Now, in some areas, the new technology has led, I think, to a new norm in terms of viewing things. That is to say, a newspaper, at least historically, would be very reluctant to publish a correction if they weren't sure they made a mistake. Now it's just easy to take something down, and stop running something or other, and that's very common. And one would like to think that the stuff taken down is not good and true stuff, but there's no doubt that the economic perils of journalism today are, I would say, far more of a threat to the press than any direct challenges to the First Amendment.
Time for two quick questions, if you can be brief.
I'll be real quick. Ken Bunning with NFOIC. Real quick question, but thinking about your fascinating discussion about WikiLeaks, the question you just got about the ag-gag bill, some of the recent cases where they tried to criminalize filming a police officer doing his job with an instant camera. Can you guys envision a case where the question of whether or not they really are journalists publishing or whether they're sources leaking becomes central to the First Amendment issue itself?
I think the only time it really becomes central is when the source has some pre-existing obligation of some legally enforceable nature. So, soldiers are different than civilians, and people that work in the CIA are different than people on the outside, and they have certain. The Supreme Court has set certain inherent limitations on what they're allowed to say. But speaking of agents now, or former agents, but beyond that, I don't think it should matter. I mean, and more important, I think the court is moving away from any sort of press-centric view of the First Amendment towards a rather broad but identical view of free speech, free press goes up to here for everyone. One of the dangers of that is that there are some areas, confidential sources, for example, in which the press has a special need for the sources, and in which it's perfectly clear that the courts would never say that everybody can make a promise of confidentiality and not have to speak in front of a grand jury. So in that sort of area, that's a side danger of where we're moving from a technological point of view. But beyond what I've said, I don't think it should matter.
I think doctrinally speaking, undoubtedly Floyd is correct. But I do think, particularly in lower courts, the presence of the institutional press, although doctrinally it may not make any difference, I think operationally it does.
Mr. Abrams, what do you think of the efforts by the credit rating agencies to claim that their work is protected by the First Amendment?
I couldn't have more of a conflict of interest. I represent Standard & Poor's. I have spent, I would say, 85% of my time over the last 2 years in cases in which that is one issue. But for your information, I will say that the position of the credit rating agencies is that if there is a fraud suit brought against them, there is no First Amendment protection. The First Amendment doesn't protect against fraud. But they, now listen carefully, we have argued and do argue that a negligence claim, for example, for being wrong because you didn't do a good enough job, should be protected when you're offering an opinion about the future, and the future being how likely it is that a bond will be repaid on time.
But shouldn't lawyers be protected by having their claims against negligence against a lawyer or an accountant protected by the First Amendment too?
No, nor should rating agencies be protected if they were talking about the past or saying, here's the situation now. The difference with rating agencies is that they are offering a prediction about how likely it is that a debt will be repaid. If the Wall Street Journal said, we don't think GE is likely to repay its bonds on time, that would be absolutely protected by the First Amendment. And the argument that my team makes Is that's the same? I'm so glad you asked.
Since we are talking about money, let me just close on this note. One of the ways that you support the First Amendment, one of the ways that you support freedom of the press, one of the ways that you support writers is by supporting, among other things, independent bookstores. And we have Philip Levy from one of our best bookstores here in town, Bridge Street Books. He is here selling books today. They happen to be mine. And this is your opportunity to vote with your wallet. And I will happily sign, and if I can get Floyd to co-sign as well, we will do so. And Philip Levy is here selling books. And
I'll just say a last thing. I'm sorry I confessed to a conflict of interest.
Well, we've been treated to a bit of unabsolute nuances, I believe, here in the selling of books and in the ardent defense of a position. But I think it is absolutely illustrative to see the thinking behind all of these rather, again, nuanced pieces. I was so glad you brought in Westboro Baptist and some of these other positions when you talk about the court, because it has been an interesting look at language, I think, that will resonate through the years. Robert's saying you cannot punish a speaker for being effective, while in a particular case, to me, echoes throughout First Amendment law. And I think what we have seen here, and in terms of questions, and frankly, with some of the participants in our audience, some of whom spoke and some who did not, among the best First Amendment minds in the country. And I hope you'll join me in thanking them for their presence.